a great honor to be here with you. Let that be the first mistake I've made running the hearing so far today, Janet. Thank you. Today, the committee will host two panels on three separate bills, H.R. 620, the ADA Education Reform Act of 2017, H.R. 3299, the Protecting Consumers' Access to Credit Act of 2017, and H.R. 3978, the TRID Improvement Act of 2017, which includes the text of several bills, H.R. 1645, H.R. 2948, H.R. 3948, H.R. 4061, and H.R. 4546. The first panel is from the distinguished House Financial Services Committee, Mr. Hill and Ms. Waters, who will discuss H.R. 3299 and H.R. 3978. And our second panel will be from the Judiciary Committee. Ranking Member Nadler and Mr. Langevin will be here, as will Chairman Goodlatte on H.R. 620. I thank you all as witnesses for being here today. Look forward to your testimony, but first I'd like to yield to the ranking member, the gentlelady from New York, for her opening statement.
And I thank the gentleman for yielding, and I thank you, Mr. Chairman, and I thank the witnesses for being here. But these three bills that we're considering tonight have one theme in common: prioritizing business over people. First, H.R. 3978 is a package of largely anti-regulatory bills that would weaken consumer and investor protections. It cobbles together 6 different bills en masse without a proper hearing or regular order, and whatever happened to considering one issue at a time. This is 6 different issues in one bill. And we are, while I'm at it, we are doing 3 bills in one rule. Considering how little we had done, we certainly seem to condense it all. The second one, H.R. 3299, is called, quote, Protecting Consumers' Access to Credit Act, end quote, which seems like a great idea until you read the fine print. And then you realize that the bill is a gift to predatory lenders at the expense of low-income consumers. And that brings me to the third measure, H.R. 620, the, quote, ADA Education and Reform Act. I've had a long career here and I had complaints about a lot of things, but I have never in my years had any complaint from anybody about conforming to the ADA, which allows disabled persons, people with disabilities, to join the world, to get to the theater, to go to the restaurant, try and get up on the sidewalk, for goodness sake, to be able to make those cuts. So I'm really concerned about this one. I think it threatens the civil rights of persons with disabilities. It imposes burdensome and onerous requirements on the victims of discrimination before they are allowed to file suit in court. The end result of this bill will be to limit access to public spaces, access supposed to be guaranteed by the ADA law. The burden of enforcing ADA compliance would then lie with the wrongdoer, not the victims of discrimination. The bill unfairly singles out Americans with disabilities and disincentives businesses from voluntarily complying with the ADA. Of all the things that we should make sure is intact, I think, is that law, which opened up the world to a lot of people. And it made me remember today when I was in the county legislature, and we had so many streets with no sidewalks at all. And I was able just to get a strip of asphalt on a little street called Jefferson Avenue that ran about 1.5 miles. And I heard from 2 or 3 people on that street that something that I hadn't really thought about. 2 of them in wheelchairs who said now they could go visit their neighbors. They could get out and go up and down the street, whatever they wanted to do. And I'm just really disturbed that this Congress would spend time trying to make it harder for persons to take advantage of the ADA. So with that, I'm going to yield back, and I look forward to listening to the witnesses.
Yeah, I thank the gentlelady for her statement. Before we go to Mr. Hill and Ms. Waters, I will remind you all that any statement you have in writing, we will absolutely make a copy and put it in the record, and we welcome your oral testimony. The gentleman from Arkansas is recognized, Mr. Hill.
Well, I thank the acting chairman today for his courtesy, and ranking member Slaughter, thank you for inviting us today, and members of the committee. Appreciate the opportunity to be with Mrs. Waters and discuss these important measures. There are two strong bipartisan bills that we are coming to you before to discuss from the Financial Services Committee. H.R. 3978 is a package of bills which were all favorably reported with the support at least 3/4 of the committee. So they are strongly bipartisan. And also H.R. 3299, Protecting Consumers' Access to Credit Act, sponsored by our Vice Chairman, Representative McHenry. Over the years, the Financial Services Committee has heard from countless hardworking Americans who are struggling to make ends meet and business owners who are having trouble accessing the financing that they need to grow their enterprises and create jobs. We've heard from community financial institutions and small businesses and startup enterprises that are drowning in a sea of Washington red tape. Let me begin tonight by sharing just a few of these stories. First, Sean, a small business owner from Wisconsin, says, I've gone from bank to bank trying to get a loan to build up my business, only to be told that my business isn't big enough. Well, how am I ever going to get big enough if I can't get a loan? Larry summed up the plight of local banks and their inability to serve our constituents when he said, regulations have significantly reduced our ability to make judgment calls on credit decisions. When I first came to First Savings Bank, I had a number of people tell me that we gave them their first loan, probably when they didn't deserve it. Today, they are the business and civic leaders of our community. I guess we made the right call then. However, we cannot make that call today. Washington has already made the call, and the answer is no. And finally, Perry from Nevada writes, I've been a banker for over 30 years, and I've never been more discouraged than I am right now. The days of making common sense decisions for the benefit of the customer are gone. For me, retirement can't come soon enough. And just this weekend, reading the papers on the plane coming to Washington today, I read the story of Mr. Richard Griffin, the owner of First State Bank of Crossett, Arkansas, a $30 million bank, who recently sold to a bank in Louisiana, and his reason, he just could not comply with the regulatory burden any longer with his 13 employees. Mr. Chairman, we hear these pleas and laments every day. The bills before us help cut at least some of that red tape that places such a disproportionate burden on both our Main Street businesses and our community financial entities. Let me start by explaining how H.R. 3978, an important package of 5 overwhelmingly bipartisan pieces of legislation, will make a difference in the lives of our constituents. The first, the TRID Improvement Act, amends the CFPB's complex TILA-RESPA Integrated Disclosure Rule, hence the acronym TRID, to simplify the closing documents consumers get when they close a mortgage. Specifically, this provision provides greater clarity for customers on the true costs of title insurance by allowing title insurance companies to accurately disclose the available discounts. The next provision, the Protection of Source Code Act, was introduced by Representatives Sean Duffy and David Scott. This bill ensures that the SEC cannot require a financial services firm to disclose the algorithmic trading source code without first obtaining a subpoena. A firm's source code is among its most sensitive intellectual property assets. This bipartisan provision balances privacy and due process concerns while preserving the SEC's ability to obtain such information when necessary. The third title in the act is Fostering Innovation Act, which was introduced by Representatives Sinema and Hollingsworth. This is to provide relief to small and emerging businesses by extending a popular on-ramp exemption of the Jobs Act for emerging growth companies in a more tailored manner. This gives them more time to financially sustain the legal and accounting and compliance costs with the full implementation of Sarbanes-Oxley and its Section 404B compliance. This is not a new issue before the Congress or this committee. but it certainly makes it easier for those businesses to comply when they get a little larger with 404B. The next title is the National Securities Exchange Regulatory Parity Act, which was introduced by Mr. Royce. It ensures further clarity and competition among the national securities exchanges by modernizing the blue sky exemption in the Securities Act. Modernizing this provision will ensure that all national securities exchanges operate on a level regulatory playing field and help protect retail investors from arbitrary acts by state regulators that may bar investors in one state from buying stock freely available to investors in every other state. Identical language to this title is included in the Senate's regulatory relief bill as approved by the Senate Banking Committee. The final title of H.R. 3978 includes a provision introduced by Mr. Stivers to amend the Safe Mortgage Licensing Act of 2008 to allow loan originators that meet specific requirements to more easily change jobs or move without losing their ability to originate loans. It does this by providing that qualified individual temporary authority to continue to make loans while transitioning, all the while maintaining the safeguards that protect consumers and prevent bad actors from gaming the system. In other words, if you're moving between banks, your mortgage licensing is maintained while you make that move. Again, each of these 5 titles in H.R. 3978 were reported out of our committee as standalone measures with strong bipartisan support. I have no doubt that they will obtain the same if considered by our full House. Now I'd like to turn, with the Chairman's permission, and discuss H.R. 3299, the Protecting Consumers' Access to Credit Act. As I stated earlier, this bipartisan legislation was sponsored by Congressman McHenry of North Carolina and was passed out of the Financial Services Committee by a vote of 42-17. In the 2015 Circuit Court opinion, Madden versus Midland Funding, the court held that while the National Bank Act allowed a federally chartered bank to charge interest under the laws of its home state on loans it makes nationwide, non-banks that bought those loans could not continue to collect that interest because non-banks are generally subject to the limits of the borrower's state. The Second Circuit's decision has caused considerable uncertainty and risk for many types of bank lending programs, driving up the cost and limiting the availability of credit to countless borrowers, particularly those with less access to traditional lending sources. But you don't have to take my word for it. According to Columbia Stanford University's study, borrowers with credit scores under 625 have seen their credit cut in half thanks to this decision. So this is clearly having national ramifications. Mr. McHenry's common sense bill reinforces the valid when made legal doctrine that preserves the lawful rate of interest on a loan originated by a bank, even if that loan is sold, assigned, or transferred to a non-bank third party. This fundamental concept, which has been precedent for more than 100 years, is the backbone of how fintech companies partners with banks. As heard in testimony before the Subcommittee on Financial Institutions and Consumer Credit just last month, banks, particularly smaller or community banks, can extend their reach and diversify their risk profile by partnering with non-banks to offer credit to consumers. Non-bank fintech providers can bring expertise to the table that the bank would not otherwise have. For example, expertise in electronic and internet marketing of loans, innovative underwriting and credit risk assessment techniques, or online statement and servicing of loans. Access to this new technology might enable a smaller bank to originate loans through these new channels, such as the internet, make loans to new markets, such as small businesses, to borrowers outside of their bank's traditional footprint, or to borrowers of a lesser credit quality, such as thin-file or no-file consumers. All of this means more competition among providers of credit, lower costs of credit, and more options and access for credit to consumers. The proposals I've discussed today will provide common sense regulatory relief. They are practical, They are strongly bipartisan, and, Mr. Chairman, they are needed. Thank you for the opportunity to discuss this legislation with the committee, and I'm happy to answer your questions.
Thank the gentleman from Arkansas. The lady from California had the pleasure of being with for just a couple of her hours on the floor last week during her 8-hour marathon presentation. I was only there for 2, but I did enjoy it. I welcome any testimony that she may have.
Thank you very much, Mr. Chairman and Ranking Member Slaughter. I appreciate the opportunity to be here today. Today, the Rules Committee is considering a number of bills, many of which would hurt some of the most vulnerable Americans, further destabilize our stock markets, harm small businesses and investors, and undermine one of the most fundamental foundational reforms of the Dodd-Frank Act by making it harder to rein in risky non-bank firms like AIG or Lehman Brothers. Turning to the first bill, H.R. 3299, is an attempt to overturn a Second Circuit Court ruling in Maiden versus Midland, LLC. In Maiden, the court declined to uphold the, quote, valid when made, quote, unquote. They failed to uphold that doctrine and held that a non-bank third party that purchases a loan cannot avail itself of federal bank interest rate preemption privileges. The valid when made doctrine, which provides that if a loan is valid at its origination, it cannot subsequently become usurious if it is sold or transferred to another person, does not exist universally in state or federal statute or case law. And while there are many good actors that have relied on this doctrine, if it were to be codified as H.R. 3299 would do, state laws protecting against usury would largely become meaningless. Payday lenders could contract with a bank to originate loans that would otherwise be usurious in a given state. H.R. 3299 is widely opposed by over 150 consumer and civil rights groups, including the Leadership Conference on Civil and Human Rights, NAACP, National Consumer Law Center, Southern Poverty Law Center, and many, many others, given that practically every nonpartisan organization representing consumers opposes this bill. Members should take pause to consider the harm Congress could cause. I'd like to speak against now H.R. 3978, a package of 6 bills that the chairman describes as bipartisan. However, there's nothing bipartisan about cobbling together bills with varying degrees of Democratic support without any input from the opposite side of the aisle. What the chairman is actually doing is forcing Democrats that may have opposed the majority of the bills in this package to vote against the 1 or 2 bills in the package they may have supported. If the chairman actually wanted to move bipartisan legislation, he would break up this harmful package and let members of Congress review each piece of legislation independently on their merits. So I strongly oppose this package and will very briefly describe each of the measures included. Title VI of the bill is the text of H.R. 4061, the so-called Financial Stability Oversight Council Improvement Act. This provision would significantly hinder the FSOC's ability to identify and mitigate threats to U.S. financial stability posed by a large non-bank financial firm like Lehman Brothers, whose failure destabilized the financial system in the last crisis. In 2015, the Obama administration made 17 reasonable changes to the process for designating non-bank financial firms as systemically risky and warranting additional safeguards. These changes ensure it is a transparent and deliberate 2-year process, but this provision adds numerous steps, making the designation process take 4 years or more. The Trump administration has already been aggressively de-designating non-bank firms, including AIG. Congress should not help them by making it harder for regulators to prevent a future AIG or Lehman Brothers from contributing to the next Great Depression. Title IV of the bill is the same language as H.R. 4546, which would weaken the standards for listing public companies for trading at U.S. stock exchanges. Today, exchanges listing standards set minimum requirements for a company's shares to be sold to the public and can only be revised if the Securities and Exchange Commission first finds that listing standards are substantially similar to those of the New York Stock Exchange. The bill would repeal that finding and encourage a race to the bottom, as exchanges would likely lower their listing standards to attract companies, even if the standards are otherwise beneficial to investors. I'm also disappointed that my colleagues on the other side walked away from our bipartisan compromise on identical legislation last Congress, which required the SEC to develop core quantitative listing standards, thereby eliminating any concerns. Title III of the bill is H.R. 1645, the so-called Fostering Innovation Act. This bill would eliminate the Sarbanes-Oxley independent audit of financial controls for up to 10 years for newly public companies, provided they have average annual gross revenues of less than $50 million and have less than $700 million in outstanding shares. I'd like to remind my colleagues that truly small public companies, those with less than $75 million worth of public shares, are already exempt from the audit requirement. But this provision would extend the exemptions to large companies nearly 10 times that size. In the wake of the Enron and WorldCom accounting scandals, Congress, on a bipartisan basis, required that public companies conduct an independent audit to improve the accuracy of financial reporting. In fact, companies that are not subject to such review are more likely to issue corrections to their financial reports, leading to investor losses and higher costs for the company. The law already provides newly public companies with an exemption for 5 years. Extending it to a decade would harm investor confidence in all such companies, hurting the very companies the bill's supporters purport to help. Title II is the same as H.R. 3948, which is an ill-timed piece of legislation if ever there was one. H.R. 3948 would ban the SEC from inspecting source code used by regulated entities to engage in, among other things, algorithmic trading without first obtaining a subpoena. I'm sure each of you has been following the roller coaster side of the stock markets these past 2 weeks, which has seen the decline of all of the major indices by more than 10%. Most experts believe that the recent stock market volatility has been exacerbated by high-frequency traders using computer algorithms to determine when to buy and sell millions of trades a second. This bill, however, would severely hamper the ability of the SEC to effectively conduct compliance examinations on registrants, including those same high-frequency traders, and to investigate market disruptions by making it harder for the capital markets cop to detect and stop bad actors. This provision will inevitably harm everyday Americans and retirees who rely on fair capital markets to invest their hard-earned savings. Title I is the text of H.R. 3978, the Trade Improvement Act of 2017. This provision would modify a mortgage disclosure known as TRID, which is meant to inform home buyers about how much they will have to pay at closing for a mortgage. Some in the industry are concerned that in states where simultaneous lender and owner title insurance policies are issued, the existing TRID disclosure does not adequately describe discounts paid to borrowers. However, this provision would do nothing to benefit consumers in states that do not provide special rates to home buyers for simultaneous policy issuance, And the provision also eliminates the Consumer Bureau's ability to amend this aspect of the rule, even if a problem arises in the future. Turning to the final provision, Title V is identical to H.R. 2948, the SAFE, or SAFE, Transitional Licensing Act. This provision helps individuals who are employed as mortgage originators move or transition to a new employer by creating a temporary licensing regime. This regime already exists for federally registered firms, and this bill would create parity for state-regulated ones. Although I support H.R. 2948 as a standalone measure, taken together, this package of deregulatory bills would threaten the strides Congress and regulators have taken to reduce risk in the financial system and restore investor confidence to our economy. As the markets continue to experience record daily declines, we should be strengthening oversight of the financial system, not weakening it. This package of deregulatory bills is strongly opposed by the North American Association of Securities Administrators, Consumer Federation of America, AFL-CIO, Center for American Progress, Americans for Financial Reform, and Public Citizen. So I would urge members to reject both H.R. 3299 and the deregulatory package of bills in H.R. 3978, and I would be happy to answer any of your questions.
I thank the gentlelady for her
You're back.
testimony. I find myself thinking about, Mr. Hill, your First Savings Bank story, because I hear that in my constituency all the time, folks. I believe what you said is many folks got their first loan there, even if they didn't deserve it. I don't want an algorithm making those decisions of local community banks. I want folks to look that family in the eye, and in our community, it was looking the YMCA in the eye. I don't think a big national bank would have given the YMCA a loan to keep going, but our small community bank did. As those decisions become harder and harder, has there been disagreement in the committee about the merit of community banks being able to make special investments in the communities? Or is there unanimous agreement that that should happen, and it's only a discussion of what the regulatory environment should look like to allow that to happen?
Well, I thank you, my friend, and I would tell you that as a general statement, there's agreement on both sides of the aisle and bicamerally with the House and the Senate that our smallest community banks, locally owned, locally operating, and our credit unions have really borne the brunt of all the regulatory increases that were primarily as a result of passing the Dodd-Frank Act. These efforts today are modest, Mr. Chairman, in making an effort to improve that. Mr. McHenry's bill would make it much easier to originate loans from small banks and get those sold into the marketplace and get consumers a better price. The TRID Act that I've worked on would make it much easier to and lower the cost of closing a home mortgage loan, and in the states that the ranking member noted would make it more clear what the consumer pricing it is, not less clear. And then on the loan originators licensing confusion that Mr. Stivers raises, this just allows a commercial loan officer that's been licensed by Dodd-Frank to make mortgage loans. They want to change employers, and they want to go to a non-bank mortgage company, or they want to go to another state, to let them have a transition period so they don't have to take the test over and become relicensed and re-fingerprinted when they're just changing employers. So it seems to me it just makes sense, and that, again, lowers HR costs and lowers transition costs for our community banks.
Ms. Waters, I tell folks back home that they really would be proud if they got behind some of the committee doors and saw how folks are working together. That licensure bill that Mr. Stivers introduced, I saw you all pass that 60 to nothing out of the committee. Had something changed in the law that required a new licensing procedure that had not been a problem before, or is this just a function of we're more transient as workers these days, and so what hadn't been a problem 10 years ago is now a problem you all have come together to fix?
Well, now let me just say that Mr. Hill is correct. There are instances where we work together and we work hard at trying to have bipartisan legislation. And as I have said, as the ranking member and one who served on the conference committee of Dodd-Frank, I've always been willing to examine those areas that are brought to our attention that may be confusing, that may need to be straightened out a bit, that may have been written in such a way that they are not quite understandable, and work with my colleagues on the opposite side of the aisle to make modifications and changes that make good sense. What, of course, I am not willing to do, and my caucus is not willing to do, is to destroy the work that we have done in Dodd-Frank reform. Many of us remember very well what was happening in 2008. We remember the destruction to our communities, the foreclosures that took place. We knew that we had to bail out certain financial institutions in this country to keep our country from going into a depression. It did go into a recession. We remember all of the harm that was done to families and to neighborhoods, et cetera, et cetera. So we certainly are not about to do anything to literally overturn Dodd-Frank with decisions that we're making in the committee. Of course, I believe that basically when one has tested properly and have been able to execute their responsibilities in a responsible way, that perhaps it does not require additional testing in order for that individual to be able to operate. So again, let me just say that when opportunities are there for both sides to agree, and it makes good sense, and it is not an attempt to destroy, work that has been done, particularly under Dodd-Frank, then we do that. Yes.
I thank the gentlelady. The gentleman from Washington State, Mr. Newhouse.
Thank you, Chairman Woodall. Appreciate you recognizing me. I, as you know, just got in late trying to catch up with the bills and the testimony, but I appreciate Mr. Hill and Ms. Waters being here with us this afternoon. From what I've heard so far, it seems to me that these bills truly do build on some of the tax reform that we have been engaged in. As Ms. Waters said, we work to refine and to tweak and to make improvements when we can. And a large bill like Dodd-Frank, there's been a lot of opportunities for that. And in order for banks and financial institutions to be able to provide homeowners and small businesses and the American people with affordable credit, I think we need to continue to look at ways to provide that relief and make those loans as affordable as possible. So I really appreciate these bills being in front of us today. I think they accomplish a lot toward that goal, and we'll continue listening with great interest and making sure that we are making perfections that will make financial activities easier for the American people. So I don't have any questions at this time, but this is, I appreciate you recognizing me.
I thank the gentleman. Gentlelady from New York.
No questions, thank you.
Gentleman from Colorado. Gentleman from Massachusetts. Gentleman from Florida. Well, I would again thank the witnesses for being here. Remind them that anything they leave in writing, we will make a part of the record. And thank you for your testimony today.
Welcome.
Thank you, Chairman.
Thank you. Thank you.
Are there any other members who wish to be heard on H.R. 3978 or H.R. 3299? Seeing none, this concludes that part of the hearing today, and we will now move to our second panel on H.R. S20. I see the gentleman from Rhode Island with us, Mr. Langevin. Welcome to the witness table, and unless you have run off the competition here, I think we're going to have someone join you here just moments from now. As we begin the the hearing on H.R. 620, I'd like to enter into the record the statement from Chairman Pete Sessions for the purposes here in the, on this hearing, and I'll have that here. Mr. Nadler, welcome to the witness table, and we will have one more chair for Judge Poe there on the end. Thank you very much for being here today. Anything that you have in writing, we will absolutely take and have entered into the record. And with that, we'd welcome any oral statement that you may have. I'll start with the gentleman from Texas, Mr. Poe.
Don't take our rights away.
Hands off the
There.
Don't take our rights away. Hands off the ADA.
Chair would remind folks that they are here as a guest of the committee. And we would.
Don't take our rights away. Hands off the ADA. Don't take our rights away.
The chair would ask members of the gallery to please refrain from disrupting the hearing. We're going to have able testimony on both sides of the hearing today.
Don't take our rights away. Hands off the ADA. Don't take our rights
We will.
Hands off the ADA. Don't take our rights away. Hands off the ADA. Don't take our rights away.
The chair welcomes all voices in the hearing today, but we cannot conduct the hearing under these circumstances.
Don't take our rights away. Hands off the ADA. Don't take our rights away. Hands off the ADA. Don't take our rights away. Hands off the ADA. Don't take our rights away. Hands off the ADA.
Chair would tell committee members we'll take just a moment here to see if we can continue in a productive fashion. If we can't, we may make some other choices.
Hands off the ADA. Don't take our rights away. Hands off the ADA. Don't take our rights away. Hands off the ADA. Don't take our rights away.
Chair would tell the members we will take a brief recess, subject to the call of the chair. Committee will reconvene. We are hearing testimony on H.R. 620, the ADA Education Reform Act of 2017. At the witness table, we have the gentleman from New York, Mr. Nadler, a gentleman from Rhode Island, Mr. Langevin, and a gentleman from Texas, Judge Poe. We would welcome any written testimony that any of you gentlemen have. And Mr. Poe, we would start with you.
Thank you, Mr. Chairman. I do have a prepared statement that I will introduce for the record.
We will make sure that is entered without objection.
Let me try to summarize, or let me summarize the issue before us today.
Let me ask the gentleman to suspend just one moment. All right, gentleman from Texas.
Thank you, Mr. Chairman. Members of the Rules Committee, this bill, H.R. 620, has to do with improving the ADA, the Americans with Disabilities Act. I am a strong supporter of the ADA. Both my parents, one's 93 and one is 92, and I have studied this issue for some time, but there's a problem with the ADA in that because of the way that it was written, it allows for lawsuits to be filed by serial attorneys and serial plaintiffs who have never visited the property, and also some don't even live in the same state in which the property that they are complaining about is. They use Google Maps and other devices to make a demand on a small business. In the demand letter that is sent to small business, and it's primarily small businesses, it tells small business that they have a violation of the ADA, and to prevent lawyer from suing the small business, they can settle this for $3,000 to $7,000. In many of these letters, the alleged violation is never stated in the letter. So sometimes the business owner gets this demand letter and doesn't know what the problem is. Sometimes they do, sometimes they don't. And then they are made with the economic decision to either settle or go to court. Most small businesses want to settle. It costs too much to hire a lawyer to defend the lawsuit. And those unscrupulous individuals that are using the ADA as a way to make money and not really improve the accommodations are using this. And it's started in California, in the South, and it's in many states now. And sometimes the violation is such as a screw is loose on a ramp that goes up to the business. And the owner is not aware of the problem, but the owner makes the decision to settle or go to court. So what this legislation does is require that there be some form of notice, not a legal book, chapter, and verse notice under the law, but a notice to the owner of the violation, and allows the owner time. I think our legislation says 180 days. There's an amendment that's proposed for 120. I'm satisfied with the amendment, but a period of time to make substantial progress to improve that violation. If there is no substantial progress within the time length, then file the lawsuit, go after them, get you a good lawyer and pay them well. That's what I'm in favor of that. I think there's also an amendment that talks about requesting a good faith effort on the part of the business to comply or substantially comply with the alleged violation. I support that amendment as well. It's become a cottage industry, and there have been, now we are seeing that there are some lawyers where states have a state ADA Protection Act like this, are losing their law licenses for doing this. A federal court in New York, of all places, made this comment not too long ago. So the cottage industry is what we're trying to do, to protect bona fide people with disabilities, so that really these drive-by lawsuits, I probably should have read this, it'd have been shorter. Drive-by lawsuits are hampering at the behest of people who are really disabled, are hurting them because of these plaintiffs who don't have to be disabled. All they have to do is figure out a way to allege that a violation may occur out of state in another jurisdiction and send the demand letter or threaten a lawsuit. So that's what we're trying, that's what this legislation does. It cuts out that cottage industry. One last comment, and then I'll turn it back over to the chairman. One of our witnesses that testified was at our hearing was Lee Kai. She owns a Donuts to Go in California. She testified at our 2016 hearing. She got sued. Lee Kai is disabled. She is paraplegic and has lost both of her legs. And she got sued over this drive-by lawsuit issue. And people like that support this because these are small business owners. Some of them are disabled small business owners. So it's just the ADA, great piece of legislation. Want to try to make it better and cut out the unscrupulous, those that are preying on people with disabilities. I yield back.
Thank you, gentlemen. Gentleman from New York, the ranking member, Mr. Nadler.
Thank you, Mr. Chairman. Mr. Chairman, H.R. 620, the so-called ADA Education and Reform Act of 2017, would undermine the civil rights of Americans with disabilities by significantly weakening the key enforcement tool of the ADA, which is the filing of private lawsuits by discrimination victims. Congress passed the ADA 28 years ago with the goals of fully integrating people with disabilities into the mainstream of American life and counteracting discriminatory social attitudes toward the disabled. By making it harder for persons facing such discrimination to vindicate their rights in court, H.R. 620 ultimately undermines these goals. H.R. 620 would, among other things, institute a pre-suit notice and cure regime under Title III of the ADA, which prohibits discrimination on the basis of disability in public accommodations like hotels, restaurants, private schools, and healthcare providers. Specifically, the bill would prohibit a disability discrimination victim from filing a lawsuit to enforce his or her rights under Title III unless the victim first notifies a business of a Title III violation. The victim must then wait up to 180 days to allow the business either to comply with the law or simply to make some undefined level of substantial progress, in quotes, toward complying with the law. No federal civil rights statute imposes such onerous requirements on discrimination victims before they can have the opportunity to enforce their rights in court. Both individually and cumulatively, H.R. 620's notice and cure provisions will have the effect of inappropriately shifting the burden of compliance with the federal civil rights statute from the alleged wrongdoer onto the discrimination victim, and perversely incentivizing businesses not to voluntarily comply with the ADA. Moreover, because H.R. 620 does not define the term substantial progress, the bill leaves it entirely to a business's owner's discretion as to whether he or she has made such progress. At a minimum, this raises the prospect of expensive and protracted litigation over the question of whether the business made substantial progress should a lawsuit be filed. Such a prospect, along with the need to wait 180 days before filing a lawsuit, may be enough to deter discrimination victims with meritorious claims from even sending a notice of a violation, much less filing suit to enforce their rights. In addition, H.R. 620's notice requirement is overly burdensome and excessive. Rather than simply requiring an aggrieved person to notify a business of the existence of an access barrier, H.R. 620 essentially requires the person to plead a legal case in his or her initial notice. For instance, a victim must cite the specific provision of the ADA that has been violated, describe whether the victim made a request to the business about removing an access barrier, and explain whether an access barrier was temporary or permanent. Such specific information may be very difficult or impossible for a victim to provide at the notice stage, particularly without legal counsel and obviously before discovery. Finally, H.R. 620 does not even address the purported problem identified by its proponents, who claim that pre-suit notification is needed to stop lawyers from filing numerous similar lawsuits alleging both federal ADA claims and state law claims against numerous businesses in order to force quick settlements. That is because many states allow for damages under their state's disability rights laws. But this ignores the fact that Title III of the federal ADA does not award damages. It only permits recovery of reasonable attorney's fees and costs, not money damages. In other words, it is state law, not the federal ADA, which provides the financial incentive for pursuing numerous lawsuits. Additionally, the filing of multiple suits alleging violations of the ADA or state disability laws says nothing about the underlying merits of those suits or the intent of the parties involved. To the extent that lawyers actually engage in misconduct, courts already have the tools to address such misconduct, including by imposing sanctions under Rule 11, refusing to award attorney's fees, or dismissing cases that have no legal or factual basis. A pre-suit notification requirement, together with a lack of any requirement to actually comply with the law, is a virtual get-out-of-jail-free card for every public accommodation in America. H.R. 620 would substantially diminish the primary incentive for voluntary compliance with Title III, which is the credible risk of being sued and having to pay reasonable attorney's fees and costs. H.R. 620's notice and cure requirements, by starkly diminishing the risk of litigation, would send a clear and devastating message to every public accommodation in America that there is no need to comply voluntarily with the ADA. Instead, the bill tells them they should simply wait and see if they ever receive a notice of violation, and never mind the rights and needs of people with disabilities. They only have to cure after they receive a notice of violation, if they do. There is no incentive left for obeying the law in the first place. Representative Jim Langevin has offered an amendment that would substantially improve H.R. 620 by removing its onerous and unjustified notice and cure provisions while preserving its education and mediation-related provisions, which may encourage voluntary compliance with the ADA. Accordingly, I urge the committee to make Mr. Langevin's amendment in order. 28 years after the ADA's passage, too many businesses still remain inaccessible to persons with disabilities. Yet instead of improving compliance, H.R. 620 excuses noncompliance and enables the marginalization and discrimination of the very people the ADA is designed to protect. As former Homeland Security Secretary Tom Ridge wrote today in The Hill in opposing H.R. 620, quote, "It is unacceptable to roll back the civil rights of people with disabilities. We should ensure access, not progress. We should expect businesses to know and comply with their obligations, not require neighbors and colleagues with disabilities to shoulder the burden of informing and educating businesses about those obligations. We should not turn the simple business of everyday life into a complex and lengthy ordeal for people with disabilities." Close quote. For the foregoing reasons, I oppose H.R. 620, and I urge the committee to make Mr. Langevin's amendment in order. Thank you. I yield back.
I thank the gentleman. Gentleman from Rhode Island, Mr. Langevin.
Thank you, Mr. Chairman, and Ranking Member Slaughter, members of the committee. I want to thank you for having me here today to testify as you consider H.R. 620, the ADA Education and Reform Act. I sit before you as the first quadriplegic elected to the United States Congress, and I'm able to serve the 2nd Congressional District of Rhode Island as your colleague because of the courageous leaders who came before me who fought for the rights of people with disabilities. The Americans with Disabilities Act was a groundbreaking civil rights law enacted in 1990 that prohibits discrimination on the basis of a disability, including access to public accommodations. For almost 28 years, people who operate businesses, schools, restaurants, doctors' offices, libraries, transit systems, and more have had already the opportunity to understand and implement the provisions of the ADA. And for people who need a reminder of what the ADA requires, there are many free resources that provide information and technical assistance. If an institution, though, is still not accessible, nearly 3 decades later, the ADA provides individuals with disabilities the possibility to sue for injunctive relief. The ADA does not allow people to sue for compensatory or statutory damages. Some states, however, have gone beyond the federal law to permit an award of damages, and those monetary awards seem to be the driving force behind the ADA Education and Reform Act. So rather than address the issue at the state level and go after the unscrupulous lawyers who seek to game the system, and I condemn those who do that in the strongest possible terms, this bill weakens the federal standards that ensure people with disabilities have access to public accommodations. For my colleagues who believe that this bill actually helps people with disabilities, let me be clear, it doesn't. The amendment that I offer here today would strike H.R. 620's notice and cure requirement. And I'm very pleased that to be offering this bipartisan amendment with my Republican co-chair of the Bipartisan Disabilities Caucus, Representative Greg Harper of Mississippi. And I want to thank Representative Nadler, the ranking member of the House Judiciary Committee, for being here to support and work with me on sponsoring this amendment as well, and for his words, and I associate myself with the gentleman's remarks. As presently written, the Notice and Cure section mandates that someone who claims discrimination on the basis of a disability relating to an architectural barrier must provide a written notice that allows 60 days for an owner to acknowledge receipt of the complaint and 120 days to demonstrate substantial progress in removing the barrier before further legal action is pursued. The idea that places of public accommodation must first receive a notice before correctly implementing a law that has been part of our legal framework for nearly 3 decades creates an obvious disincentive for ADA compliance. After all, if this were to pass, why would someone try to comply with the ADA? They would potentially just wait until they're notified. And if they're not notified, hey, they can skate by and never have to comply with the law in the first place. This is the wrong approach, Mr. Chairman. Further, any suggestion that we could reduce the time frame of a notice or the amount of information required in a notice misses the point. There is nothing that can be done to improve a notice requirement that shouldn't exist in the first place. The proposal of a notice ignores the tenets of the ADA that support an indisputable right to inclusion and respect, and quite frankly, it's insulting. No other civil rights law requires protected class members to hand a notice to people behaving in a discriminatory manner in order to educate them without any guarantee the situation will improve. The dignity to eat a meal with our families, join a business meeting, access a restroom, gain entry to a train platform, or attend a first choice college that we've been accepted to, all of these activities are already challenging for someone with a disability. All of these activities will be placed even further out of reach if this bill passes, because it's easier to take away the civil rights of people with disabilities, people like me, than to fix the root of the problem with bad actors at the state level. I recognize that there are some people who generally struggling, people who are unfairly targeted in states that have fostered an environment that fails to protect against drive-by lawsuits. And again, I condemn these drive-by lawsuits in the strongest possible terms. However, this bill is a blunt tool that wrongfully impedes the civil rights of all people with disabilities, when the focus should be on creating lasting solutions that serve the unique populations and interests of those in the states. My amendment, Mr. Chairman and members of the committee, would keep program funding for ADA education, and maintaining language supporting alternative mediation pathways relating to architectural barriers outside of the existing framework within the Department of Justice, and I applaud and support those provisions of the bill. But I remember what life was like before the ADA was enacted into law. Passage of H.R. 620 in any form that includes a notice will mark a return to those days. By supporting this bill with a notice and cure period, the doors that were once opened by the courageous men and women who came before me will close to future generations. My friends, I ask you to support my amendment I thank you for your consideration, and I'd be happy to answer any questions.
I thank the gentleman for his testimony. I'm not a civil rights attorney, and I have met with incredibly earnest men and women on both sides of this issue back home. I'm all about punishing folks who are malicious. I've met with a lot of folks who don't have a malicious bone in their body, but who live in fear and thinking about civil rights. As I have talked with folks about these drive-by lawsuits, they seem to target folks not with surnames like Woodall and Smith and Jones, but surnames like Patel and Kim and Romansky. And I wonder, as I listen to those stories of first-generation Americans trying to pursue their dreams here, trying to get it right, folks who weren't even in this country when the ADA was passed, with support for more than 90% of the members on both chambers, not a partisan bill, but an American civil rights bill. What are those others, because I'm not a civil rights attorney, what are those other civil rights cases where suits can be filed before the injury? If you put up a sign at your grocery store that says no Christians allowed, that's just a free speech statement right up until a Christian gets turned away. What are those other cases that can help me to understand the notice? I appreciated the gentleman from Rhode Island's recognition that drive-by lawsuits don't have a place. That doesn't support what we're trying to do to provide access. What is the parallel in other civil rights areas that I might have seen, and what can we do to go after the pernicious nature of predatory lawyering while absolutely committing ourselves to the betterment of civil rights protections?
Well, Mr. Chairman, I'll point out the obvious. If we think about cases where in a situation where a restaurant had a section back in technically within my lifetime years ago when African American people were not free to sit where they wanted to sit on a bus or in a restaurant, or where there were situations where signs were posted, Irish or Italians need not apply. If that happened today, it would be pretty outrageous, and it clearly is against the law. But at one point, it wasn't. If a situation like that existed today, and someone didn't change their policy or take that sign down until they were notified, that's what we're talking about right here. It's the same thing with an accommodation.
I take the gentleman's point about, hey, I have in fact been injured, and now you're asking me to make notice, and I'm the only one being asked to do that. I guess my question was I actually haven't been injured. I am aware that there's no pool lift at your hotel. I'm not traveling to your state. I'm not planning on going to your hotel. I don't have family members in your state. I am never going to be at your hotel, but I'm aware that you are not complying with the ADA based on information I have had, and so now I'm going to file a suit. Mr. Nadler?
Mr. Chairman, the analogy doesn't hold. Let me put it this way. Forget the question for the moment of someone putting up a sign that says no Jews or Irish need apply. But if that person refuses to serve a Jewish person or an Irish person or a black person who comes into his store, he doesn't need to be told that he's violating the law. He's violated the law by doing so. Now, he's violating the law the moment he doesn't put in the accommodation. He already violated the law. Now, it may be that someone doesn't complain. It may be that someone who is wheelchair-bound drives by the family drives by in the station wagon with the person in the wheelchair and doesn't stop there because they see that there's no way that wheelchair can access the place. It may be that many people are damaged by the fact that this place is not accessible because he hasn't complied with the law, and they don't even bother complaining. They're just frustrated and go look for the next place. So the issue isn't or I should say, the issue is that he's in violation, when you're supposed to maintain certain standards. Just like if the law says, if the building code says your floor shouldn't collapse under less than 600 pounds, nobody asks you for a notice of that. If your floor isn't going to hold 600 pounds, you've broken the law. So you've broken the law the moment you do not maintain that. And people may be damaged that you don't even know about. And the fact is, and now, what this bill would ask is that, in effect, it would say, don't bother complying with the law at all until someone complains. And many people may be damaged and not complain. And once someone complains, then you have, in effect, 6 months before that person, you have 6 months to cure. Why shouldn't you be bound, like any other law, to obey the law quickly? Now, when the law was first passed, it gave people a certain time period. I don't remember from 1990 what time period people were given to bring their places into compliance. But once that is done, it's your job to keep your place in compliance, with or without a complaint.
Judge Poe, you said you were not attached to one set of timelines or another.
I would like to just make one comment. This is a private right of action. This is regarding the private right of action. Remember, the federal government has a cause of action with the Attorney General for businesses that don't comply with the ADA. Second, there are no damages involved in this. So the gentleman from New York talks about damages. They're not damages for us, monetary damages. All the goal is of the ADA is to get businesses to comply with the law. And this legislation helps businesses comply with the law because they may not know that a screw is loose. So put them on notice, then they comply with the law. But this is only dealing with the private cause of action. This is not dealing with the federal cause of action, which businesses under the law will have to comply with as well. So if the goal is not to get lawyers money, but to drive-by lawsuits, but the goal is to get businesses to comply with the law or suffer the consequences, put them on notice, and they give them time, good faith time to comply, and if they don't, sue them.
We already saw much of the passion that is on this issue, and it is always hard to deal with those issues that are the closest to each of us. But it helps me to have three witnesses such as yourself to take us through this. I appreciate that.
Can I make one further comment? When I referred to damages, I didn't mean monetary damages levied against the business place. I meant that the disabled person is damaged by not being able to access the place. And he may not even complain, or she. He may just go and look for the next place, but he's been damaged. Now, it is true that the law is a very mild law. It does not impose punitive damages or consequential damages. In fact, we normally in the Judiciary Committee have a standing dispute for the last 25 or 30 years. Should you permit, and if so, how much, punitive damages? But normally, compensatory damages are always allowed. You are damaged by someone's negligence, you sue them, and you get the compensatory damages. Here, we don't even apply compensatory damages. All that happens is the only damage is attorney's fees to enforce the law. So it's very mild. And now we have this bill that comes along and says, don't even do that. And if this bill were to pass, there is no monetary or economic reason why any business, now there may be conscience reasons for some people, but not everybody's a nice guy. There would be no monetary reason whatsoever, no economic reason whatsoever for any business to comply with the law until someone sued them, and then they have 6 months. Because why bother complying? It would cost you some money to fix the place and make it wheelchair accessible, for example. Why bother spending that money when it may be that no one will complain? Why bother going into compliance with the law just for the heck of getting into compliance with the law? And that is wrong, and it's why this bill is not a great bill.
I thank the gentleman. The gentleman from Texas.
Thank you, Mr. Chairman. Mr. Nadler, you say that there would not be an economic reason to comply. Well, I actually disagree with that. I built a medical office in the middle 1980s, and I built a medical office in the early 1990s. And that, well, I will tell you the experience was vastly different before and after the passage of the ADA. I could not get a local building permit for a medical office that did not have every bathroom with a 5-foot turning radius to accommodate a wheelchair. That wasn't the case in 1983 and 1984, but it was certainly the case in 1990 and 1991. So, in fact, I would not have been able to get a building permit because of the local building codes had to be ADA compliant. Is that not correct?
I assume it is correct. That the building code would, in most jurisdictions, maybe all would say that.
So most reasonable people would not build a bathroom that didn't have a 5-foot turning radius and hope they didn't get sued, because the cost of fixing that problem would be bigger than anything that we're talking about here as far as the legal fees. Judge Poe, let me just ask you, some of the material we were given in preparation for this says in 2013 there were approximately 2,700 lawsuits, and in 2017 over 7,500 lawsuits. Is that correct?
Yes.
So can we infer from that that people just stopped complying with federal ADA laws and had to be sued to come into compliance?
No, I don't think that's what we have to comply or infer from that. I think we infer from that is a couple of things. One, remember there's a federal law that requires this, but these lawsuits have become very profitable for the unscrupulous. And I believe that the people who suffer are actually people who have disabilities. Businesses, I think most businesses want to comply with the ADA, especially retail businesses, because of business. They want the business. They don't want to cut off a whole section of the community. They want everybody. But it tells business, and the purpose of the law was to make businesses compliant with the disabled. So if that was the original purpose of the law, not to gain monetary damages, but to make people comply, this is a furtherance of that by making businesses comply where they may not know what they did in violation of the ADA. And that's so hope that answered your question.
I think so. So someone who's building a building goes to considerable expense to build all bathrooms that are ADA compliant, door frames that are proper width to allow people entry and exit, wheelchair ramps where they're required. So they've put a significant amount of capital into that, either improvement or building that building de novo. But then the mirror is too high, or the faucet isn't quite right. I mean, as a business owner, I would appreciate the opportunity to be able to correct that. I've obviously already established the intent of wanting to comply with the ADA, gone to considerable expense to build a bathroom that has a 5-foot turning radius. It's more expensive than what otherwise might have gone in that building. But if there is a problem, why not give someone an opportunity to correct that before serving them with a lawsuit?
Well,
Yeah.
if I can just finish the answer. I think most businesses want to operate in good faith, but these letters that are coming into businesses don't always tell the business of the problem, so they settle, and they're still not ADA compliant because they never knew about the problem.
So the problem's not solved.
And the problem's not solved.
Well, let me just ask you a quick, I'm sorry, did you wish to?
I just wanted to point out that there are lots of things you can do that don't require a building permit. And in fact, some of what, and therefore, there are lots of things that still would be non-compliant despite the fact that presumably the municipality would require building permits issued to be compliant, but you may very well have establishments that are not compliant and that want to make changes, certain kinds of changes that don't require building permits. And there are other things that may seem minor to some people, but that can be insurmountable for someone in a wheelchair or someone who's disabled.
So just, and I have had constituents bring this to my attention. It is generally new construction where there has been a good faith effort to comply with all of the standards. Something is not quite right, and they're not given an opportunity to correct it. I agree with the judge. Why not give them an opportunity to correct it? If you don't even tell them what the problem is, then the problem is not solved. And so the next person is still going to have a problem. If we want to correct the deficiency, it seems like it's only reasonable to tell people what that deficiency is. Judge, let me just ask you a question because it was brought up that some of these are state court lawsuits and some are occurring under federal law. Is that correct?
That is correct. They're in both places.
So you and I are from Texas. Am I to believe that under Texas law that, is Texas law more harsh than federal law?
I can't answer that question. I don't know.
Yeah, I can't either, but I don't,
I'll
somehow
find
I
out
don't
for you,
expect
though.
so. But that's just a feeling that I have. Mr. Chairman, thank you. I'll be happy to yield back.
Thank you, Mr. Chairman. I think we need to be reminded here for just a minute that this law was passed in 1990. Let me tell you why. History of disability rights in this country is marked by many challenges yet to be resolved, but it's marked by major victories such as the ADA. The activists, the policy experts, and politicians came together in a bipartisan manner to pass the law and redesign society. Before the ADA, most of the country was inaccessible to people with disabilities, but having added a host of accommodations, including curb cuts, ramps, closed captioning, accessible public transportation, and American Sign Language interpreters, we have made unbelievable progress. Can you believe it that it took us to 1990 to do that? I mean, cuts in the curbs, for heaven's sake. We watched people wrestle wheelchairs up on the sidewalk and didn't think maybe we should put a curb in the sidewalk. But this editorial goes on to say that such a feat could never happen today. The bipartisanship is just too intense. But that doesn't mean that our fractured Congress should be allowed to disrupt almost 3 decades of making the United States better. We can't let a few bad lawyers and a few stingy business owners resurrect barriers that we have worked so hard to tear down. And Mr. Langevin, I want you to tell us, if you would, please, a bit what your life was like before the ADA. Because I think you have to live it, have somebody in your family. Apparently, if it doesn't affect you personally in some way, you're not supposed to be bothered with it. But what I get most from this debate is the problem here are unscrupulous lawyers doing lawsuits. Why aren't we going after them instead? I mean, why do we go after the people who have disabilities and disadvantage them instead of going after the villains? Have we really reached a stage where we can't do that? Is Congress of the United States too impotent to go after those unscrupulous lawyers? Isn't that the answer to this? Well, is it? Is this the answer, Mr. Doctor? Yeah.
I would certainly say it is, and I would also say that
if there's
why-
7,500 lawsuits, and we're impotent to stop that.
Yeah, and if there's if the problem is sending a letter and not actually telling the person
Right.
what's wrong, then why not have that as a requirement? They at least have to tell the
I tried to
business
get
owner
in your
that-
place last
right.
week and couldn't. Is that the
Right,
kind of
yeah,
thing? But
you know.
there's no requirement for that at all.
Right.
And
And
I believe this is a bill that's not going to solve a lot of problems. Mr. Poe, I know you're such a wonderful man, and we worked together some years back. I don't know if you remember, but you had a constituent who was being held against her will. Do you remember that?
Yes, ma'am.
And enjoyed working with you so much and learned a lot from you. But I don't understand why we need this. I mean, I looked at the people from the audience who were wrestled out of here. Think what it took for a lot of them just even to get here, just to get it. And the Capitol's not that accessible. But the idea that we would, I remember going to the theater and it never occurred to me there are no wheelchairs in it. Or going to a restaurant, I didn't look for the wheelchairs. But it certainly means a lot to me as a member of Congress and somebody who can work to make things better, that everybody now can enjoy it. And I thought the public accommodations law, and I'm not a lawyer either, but I believe that it said if you open a restaurant, a place for public accommodations, you have to serve the public, all of it. You cannot discriminate. Is that correct? Well, for a long time, up to about 1990, we discriminated against people in wheelchairs. And probably people who were blind. I don't want to go back to any of that. And I don't want to put more burdens on them. We have to feel very careful. Just please keep our hands off their ADA. And Mr. Lanchman, I did ask you a question. If you'd remind us a little bit of what it was like. You were shot, I think it's age 16? Yeah.
That's right, Representative Slaughter, that I was injured in 1980. I was a young police cadet. I was in the police cadet program, Explorer Scout program, and learning a lot about law enforcement. I was in the police locker room when
you were in high school.
I was in high school. A
Yeah.
police officer's gun accidentally.
So that meant
went
that you
off,
couldn't
and,
do what other guys did in high school, like basketball, football, track, all of it.
That's right.
All
but-
gone for you.
That's right. And it was a full 10 years before the ADA was passed. So I can remember, for example, not being able to get into public accommodations. I remember what that was like. I can remember being accepted to the college of my choice. Very excited about that. But then going to tour the campus, realizing that there was no way that I was going to be able to navigate that campus independently. And so I went to an alternative school. I went somewhere else. I had a great education, but it wasn't my first choice. It was a backup choice because it was accessible. I can remember what it was like being able to vote. I was not able to vote independently on my own without bringing someone into the booth until it was actually years after the ADA was passed, and I became Secretary of State, and I overhauled our entire election system and brought in new equipment that was user-friendly to everyone. But there's a number of things that I could continue to list. The point is the world has changed for the better, and undoing the promise of the ADA, weakening it, though even some well-intentioned changes that my colleague is proposing making is going to weaken the ADA and send us backwards, not move us forward.
I agree with you. I think this is a foot in the door. And if this were to pass, that the ADA would no longer be inviolate as it has been, because total approval. I was here, and it was a great occasion, totally bipartisan. Mr. Natter, you wanted to say something?
Yes, I did. One other problem with this bill, it's bad enough that it removes the incentive to comply with the law until after someone complains. But if you want to complain about an establishment, you have to describe the ADA violation with the specificity of a legal complaint in the notice to the violator, including the specific ADA provision being violated and whether an access barrier was temporary or permanent.
You mean
You can't simply send a letter saying, I can't get my
couldn't get to-
wheelchair
yeah.
through your door. You have to say this violates section 102.6 of the ADA.
So you have to hire a lawyer.
And in fact,
Yeah.
and such specific information may be very difficult or impossible for a discrimination victim to discern or provide without a lawyer. So this bill makes it difficult just to file the complaint. Filing the complaint saying that I can't get my wheelchair through your door is not sufficient. I don't know why the bill requires that the specific provision of the ADA that it violates be listed. I would think the violator's attorney could tell him that, or I don't even know why he needs to know that, except that people can't get the wheelchair through the door.
May I make one comment?
Of course.
The problem is with the attorneys.
Yes.
Because people who are not disabled go to lawyers to get them to send the demand letter to business where the plaintiff has found something on Google Maps that may not be in compliant with the ADA.
Right.
So they're not people who are disabled. They are people who are using the system to make a profit.
And I
This is a
understand that,
recent,
yes.
this is a recent phenomenon.
That's the reason for my question of why are we going after them and not punishing the disabled?
Well, that,
Why are we making why making disabled responsible for going through all this action and waiting 6 months?
because when the lawyer then sends the demand letter to the business, they have to put them on notice so they can cure. Because the goal is not to allow a lawyer to get a bunch of attorney's fees, but to cure, to give notice and cure so that the ADA can be compliant, so more people can have access.
And we can't stop that.
Well, this is one way to stop it.
I don't see that necessarily, that to have a lawsuit over it. I agree with what you all said a while ago. But as long as unscrupulous lawyers are doing things that make it so bad, I know that maybe we should look at that as a way we should start out. But I really think that to violate the ADA and start weakening it is not the way we want to go. I'll yield back.
Gentlelady yields back. I know the witnesses have heard the bells ring. 10 minutes left in that vote. We'll keep an eye on it, but we'd like to go as long as we can so we don't have to bring you back after the vote series. Gentleman from Massachusetts.
I just want to say, Mr. Poe, with all due respect, I strongly oppose this bill. I've been inundated with calls from my district. I just got off the phone with the superintendent of the public school system in Northampton, Massachusetts, very much opposed to this. And look, this is the Rules Committee. I think one of the things I hope that we can all agree on is making Mr. Langevin's amendment in order. I hope that's not going to be controversial. I think this should be an open rule, given the controversy, but at a minimum, we should have Mr. Langevin's amendment in order. With that, I yield back my time.
The gentleman from Georgia.
Thank you, Mr. Chairman. Look, I'm going to be on the floor with this in the rule tomorrow, and there's several things here that really I just want to say, but I'm going to be short because I'll be here tomorrow. And Ms. Lamb, we've talked about this before. This is not an issue in which I have, as I think Ms. Slaughter said, have no attachment to. I have a lot of attachment to this. My daughter has spina bifida. She is in a wheelchair. She's never had the ability to walk. From birth, she never walked. The thing that I find so hideous in the reason that Mr. Poe brought this, and we've been through this twice now in 2 large hearings about this, and I think there's been good points made all around. But number one, I think at the end of the day, there's several arguments that have been made here today that are disturbing. Number one, there's the argument that we don't need to do this as far as cure, and we go after the lawyers and those kind of things. And that's perfectly fine, except to the point, except they're making money off of, they're using my daughter and they're using other disability folks as a profit motive, or they're using them as money. I don't like that, and I think this is an issue that we've got to deal with, and it's just wrong. Number two, as far as business, Mr. Nadler, that you talked about, that they can't get into, and saying that you're requiring something of them, of someone who wants to, a disabled or a non-disabled, whichever, because this provision right here allows for non-disabled persons to sue or to send letters of demand. The issue here is that in some way diminishes the rights of disabled and diminishes the rights of those in going forward. I don't say it diminishes it all, because you also have to be, it also puts the role, and even more so of a victim of someone with a handicap, into saying that they're either too frail or they don't have resources to actually demand something. At a certain point in time, you have to understand, in my mind, especially in dealing with this, because something I never wanted to deal with, and neither did you. Because yes, I understand that 12-inch gap or a 6-inch might as well be a mountain to a person in a wheelchair. But to imply that just simply, if they want to see something corrected, sending and saying, and look, I think there's an amendment that will just and we can deal without specificity. To imply that they don't have a reaction there is just, to me, is making them even more victimized, and they shouldn't be that. The disability community is one of the strongest communities around. It's something that needs to be fostered and continued. And I've been on the phone with this. I've gotten calls from people, and unfortunately it's been put out into the disability community, that this just blows up the ADA. It takes away everything. That is false and does not need, now we can disagree on the specifics here, but let's not have out in the community where, as I got a call last week from a family friend of ours that basically says, well, this just does away with the ADA. They can build whatever they want. They don't have to get, I said, that's just a lie. Let's deal with the issues that we deal with, and we can have general disagreement on how this actually takes place. But I think in the end of the day, from my own perspective, the disability community is very strong. And businesses that do want to start and don't want to fix issues, and when they're made notice of, instead of being a trout for money from trial lawyers, that's something that we just need to do away with. But also, one of the last points that I want to make in this situation is this. The discussion going forward should be about what this does and what it doesn't do, and whether we agree or disagree. But at the end of the day, I believe when we simply allow back, we have issues in communities Mr. Burgess brought up in which there are disagreements on what, I've been with building code officials who will interpret one code one way, it comes back and it's interpreted another way, and when you compare it to the AD, it was completely different. All we're trying to do here is what is we look good for at the end of the day, and who are we protecting? To be against this, you're protecting trial lawyers who do unscrupulous stuff. If that's the way we want to frame this, fine. Let's frame it that way. If you want to be against this bill, you're just protecting those who want to go out and basically use the disability community to do that. I know, Mr. Nadler, you don't really agree with that. But you smile about it. But by protecting it, in some ways you do, because there's been no proposal here to say how we can actually fix this past a lawsuit. And I think the interesting issue here for me is that let's get the education here. Let's get it done. And if a business don't, then let the community know. That's what we do. We let the community know that this business doesn't want to apply. And if they do, most people in business want to open a business, keep a business open, and keep everybody in the community coming to it. If they don't, they pay the price of that thing. We'll have more discussion about this tomorrow, but I just want it framed also, that which has not been framed here, is, look at how the disability community is being used in these lawsuits. They're being used for profit, and that's wrong. I yield back.
Gentleman yields back. Gentleman from Florida.
Yes, Mr. Chairman, I ask unanimous consent to include in the record 10 letters opposing this particular measure.
Without objection, those will be included.
Quick observations, Mr. Chairman. It took 28 years ago for this measure to come into force in effect, and it would seem to me that businesses have had sufficient time in order to be able to comply. And I know Judge Pohl's intentions are extremely admirable. I would join him and others in condemning unscrupulous lawyers. But I believe that Rule 11 and appropriate sanctions might very well obtain. And I don't think we should allow for federal civil rights statutes to impose an onerous requirement on disabled people, which would be the only ones that would be subject to this particular measure. With that, Mr. Chairman, I do wish to say two things. It took a long time before we got women's bathrooms on the second floor. And one of the proudest moments that I witnessed here was the day when we were in the majority, that we were able to make the speaker's rostrum able to have Jim Langevin access to serve as Speaker Pro Tem. Progress is being made, but 28 years should have allowed that every city should be like Berkeley, California, that took care of this 40 years ago.
Gentleman yields back. Gentleman from Oklahoma. No questions. Gentleman from Colorado. No questions. Gentleman from Colorado. I thank the panel for its testimony today, and this concludes the hearing on H.R. 620, unless there are any other members who wish to be heard. Hearing on H.R. 620 is concluded. I didn't say the words close, I said concludes. If I could ask the witnesses to, having concluded the hearing portion on H.R. 620, the chair will be in receipt of a motion.
Mr. Chairman, I move the committee grant a rule that provides for considerations of H.R. 620, the ADA Education Reform Act of 2017, under a structured rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and the ranking minority member of the Committee on the Judiciary. The rule waives all points of order against consideration of the bill. The rule provides that the bill shall be considered as read. The rule waives all points of order against provisions in the bill. The rule makes in order only those amendments printed in Part A of the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by the member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in Part B of the report. The rule provides one motion to recommit with or without instructions. Section 2 of the rule provides for consideration of H.R. 3299, the Protecting Consumers' Access to Credit Act of 2017, under a closed rule. The rule provides 1 hour of debate, equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services. The rule waives all points of order against consideration of the bill. The rule provides that the bill shall be considered as read. The rule waives all points of order against provisions of the bill. The rule provides one motion to recommit. Section 3 of the rule provides for consideration of H.R. 3978, the TRID Improvement Act of 2017, under a structured rule. The rule provides 1 hour of debate, equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services. The rule waives all points of order against consideration of the bill. The rule provides an amendment in the nature of a substitute consisting of the text of Rules Committee Print 115-59, modified by the amendment printed in Part B of the Rules Committee report, shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule makes in order only the further amendment printed in Part C of the Rules Committee report. If offered by the member designated in the report, what shall be considered as read shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendment printed in Part C of the report. The rule provides one motion to recommit with or without instructions. Section 4 of the rule provides that on any legislative day during the period from February 16, 2018 through February 23, 2018, the journal of the proceedings of the previous day shall be considered as approved, and the chair may at any time declare the House adjourned to meet at a date and time to be announced by the chair in declaring the adjournment. Finally, Section 5 of the rule provides that the Speaker may appoint members to perform the duties of the chair for the duration of the period addressed by Section 4.
You've heard the motion of the gentleman from Oklahoma. Is there any amendment or discussion? Hearing none, the question on the motion of the gentleman from Oklahoma. Those in favor will say aye. Aye. Those opposed will say no. No. Opinion of the chair, the ayes have it. The motion is agreed to.
Roll call, please.
Gentle lady from New York asked for a roll call. Clerk, call the roll.
Mr. Cole. Aye. Mr. Cole, aye. Mr. Sessions. Mr. Burgess. Mr. Burgess, aye. Mr. Collins. Mr. Collins, aye. Mr. Byrne. Mr. Newhouse. Mr. Newhouse, aye. Mr. Buck. Aye. Mr. Buck, aye. Ms. Cheney. Ms. Cheney, aye. Ms. Slaughter.
No.
Ms. Slaughter, no. Mr. McGovern. No. Mr. McGovern, no. Mr. Hastings. No. Mr. Hastings, no. Mr. Polis. No. Mr. Polis, no. Mr. Chairman.
Yes.
Mr. Chairman, aye.
Clerk will report the total.
7 yeas, 4 nays.
The motion is agreed to, in which case the gentleman from Georgia will be handling this for Republicans.
And Mr. Polis from Colorado.
Gentleman from Colorado. And I can advise members there are no further meetings scheduled this week. The committee stands adjourned.